to date. Who's the appellant?
Yes, Your Lordship.
Would you like to
Indeed.
make a start?
If it pleases Your Lordships, my name is Mr. Ahmed, and I am Senior Counsel for Billy Bunter, who is the appellant in this case. I'm assisted by my Junior Counsel, Mr. Briggs, who will be addressing Your Lordships on the second point of appeal. My learned friends opposite, Mr. Gumby and Miss Gill, appear for the respondent, St. Bashams. Would Your Lordships benefit from hearing a summary of the facts of the case?
We're quite familiar with the facts, so you can move on.
Indeed. My Lords, I shall be addressing the first point of appeal, namely that Mr. Justice Oldscore was wrong to hold that the respondent is not a public authority within the meaning of Section 6 of the Human Rights Act 1998. I shall be making one submission in furtherance of this point of appeal, namely that because the court is itself a public authority, it should in any case intervene to safeguard the appellant's convention rights. My Lords, might I proceed with my first submission?
Yes, please.
Section 6, subsection 3 of the Human Rights Act 1998 provides a definition of a public authority. I refer Your Lordships to tab 1, page 1 of Your Lordships bundle. My Lords, may I proceed? Section 6, subsection 3 states that a public authority includes a court or tribunal and any person certain whose functions are functions of a public nature. It is important to understand that Section 6 of the 1998 Act does not provide a full definition of a public authority, as it leaves it to the court to decide. Furthermore, I draw Your Lordships to the case of Aston Cantlow and Wilmcote with Bilsey, Parochial Church Council and Warbank and another, which is reported in the appeal court for 2004 at page 546.
Now, at this point, are you still arguing the court is a public body, or are you arguing that the school is a public body?
This is my first submission. This is the first part of the submission, arguing that the respondent is a public body.
Thank you.
This case can be located under tab 3, page 1 of Your Lordship's bundle. My Lords, are you familiar with this case?
Yes.
The case of Aston Cantlow established that a hybrid body, also known as a functional public authority, is one that only a public authority, by virtue of the fact that it is performing a public function, as opposed to a pure public authority, such as a government department that is a public body no matter what it does. In the instant case, the respondent cannot be a core public authority because the nature of its functions are in no sense governmental. Furthermore, the respondent is a private school that is privately funded as opposed to being funded by the state. Therefore, our focus will be on whether the respondent is in fact a hybrid body performing both public and non-public functions. I refer Your Lordships to the case of Regina and Jockey Club, ex parte Massing Bird Monday, which is reported in the All England Law Reports for 1993 at page 207.
Is it in your bundle?
Yes, this can be located under tab 2, page 1 of Your Lordship's bundle. My Lords, are you familiar with this case?
No.
A disciplinary committee concluded that the conduct of the applicant as chairman at the race inquiry was such that he should not continue to be chairman. The applicant contended that the decisions of bodies whose powers were derived from a royal charter were in general susceptible to judicial review, and that the procedure followed by the disciplinary committee had been manifestly unfair. The Jockey Club argued that its decisions were not susceptible to judicial review because it was a domestic body which derived its jurisdiction from contract. Does that answer your Lordship's questions?
Just going back to Aston Cantlow, now that case you mentioned
Yes.
earlier sets out factors to be taken into account when considering whether or not something is a public body. Can you take me through that and make that relevant to this case?
The factors relevant to this case? The factors that I considered is that whether the body in question has any control or any mechanisms of governmental control. Secondly, it'll establish whether the body in question is exercising a private function, a function of a private nature or public nature.
So in this case we've got a school
Indeed,
that's privately funded
indeed.
and not publicly funded. What do you
Yes.
say to that?
Our attention is going to be turning onto a hybrid public authority in this case.
So
The
you
fact
accept
that
that point
it's
against you,
performing
is it?
both a public and non-public function.
So just take that point then. You said
Okay.
it performs both a public and private
Yes.
function. So are you saying we could equally rule against you then in this case?
Well, my lord, my lady, I was planning to address this issue at a later point of my submission. Of course, if your ladyship prefers, I will deal with it now.
Sure.
May I
Yeah.
proceed? Thank you. I would like to draw your Lordship's attention to the words of Lord Justice Neal at page 220, page D of the judgment. The relevant authority can be located under tab 2, page 2 of your Lordship's bundle. My Lords, may I proceed?
Yes, please do.
In order to succeed, it is necessary for an applicant to show that the relevant decision was one which infringed or affected some public law right of the applicant. In the instant case, the decision to permanently exclude the appellant constituted an infringement of the appellant's right to fair trial under Article 6 of the Human Rights Act 1998. Furthermore, the decision to punish the appellant with 4 strokes of the cane in front of the whole score at morning assembly was an infringement of the appellant's right not to suffer torture under Article 3 of the Convention. Clearly, on the facts of this case, the relevant decisions made by the headmaster, Mr. Wacker, have infringed some public law right of the appellant. I refer your Lordships to the case of Aston Cantlow, which is previously cited. I refer your Lordships to the words of Lord Nichols of Birkenhead at page 555, paragraph B of the judgment. The relevant authority can be seen under tab 3, page 2 of your Lordship's bundle. My Lords, may I proceed?
Yes, please.
A hybrid public authority exercising both public functions and non-public functions is not absolutely disabled from having convention rights. In the instant case, the fact that the respondent is a private body with the function of a government-assisted places scheme means that the nature of this function is public. Furthermore, the respondent is delivering a function of education, which in itself is a function of public nature, regardless of whether it is privately or publicly funded. Furthermore, I refer your Lordship's attention to the publication on human rights, meaning of public authority under the Human Rights Act, published on the 3rd of March 2004 by authority of the House of Lords and the House of Commons. The relevant area can be located under tab 4, page 2 of your Lordship's bundle. I direct your Lordship's attention to the words, to page 22, paragraph 62 of the report. My Lords, may I proceed?
Yes?
Functional public authority status should not imply that an organisation is institutionally connected with the state, nor need it require that the state exercise control over its management or operation. Rather, it acknowledges that the function being performed or the service being provided is public in nature, irrespective of the public or private status of the organisation involved. In the instant case, the functions being performed by the respondent is public in nature, irrespective of the public or private status of the school. Furthermore, on the facts of this case, the respondent is also providing a service which is public in nature, due to the fact that the appellant attends the school under the government's assisted places scheme.
This particular document that you referred to, you've given us 2 pages of it.
Yes.